Ladies and gentlemen, we now proceed to special presentation number 8, sorry. Yeah. And we have Professor Dr. Unku Rabia Adawiyah Unku Ali with us. Sabah al-khair wa tafa'ul, hayyakumullah. Ladies and gentlemen, Musharikin al-Kiram, we are honored to have Honorable Professor Dr. Unku Rabia Adawiyah Unku Ali, Deputy Chair, SAC Bank Negara Malaysia and Securities Commission Malaysia, to deliver a special presentation this morning titled Digital Assets and Tokenization in the Islamic Capital Market Sharia Insights. Please join me in welcoming Professor Dr. Unku Rabia Adawiyah. Tafaddalu.
Bismillahirrahmanirrahim. Alhamdulillahi rabbil alamin wa bihi nasta'in. Wassalatu wassalamu ala Rasulillah wa ala alihi wa sahbihi ajma'in. Assalamualaikum warahmatullahi wabarakatuh, and good morning to all of you. So, Alhamdulillah, I've been asked by the organizer to actually speak about digital assets and tokenization in the Islamic capital market and some Sharia insights. So actually this topic is a very big topic, and I'm just given about 15 minutes to cover the main aspects of the topic. So hopefully I'll be able to go through with you and try to highlight what are the issues that is close to my heart in terms of the Sharia considerations in digital assets and tokenization. So basically, can we go to the next slide? Basically, if you look at digital assets, it is something which, is the slide moving? No. Okay. It is something which is a global trend. A lot of people are talking about, it's something that we need to adopt, right? And increasingly we can see that digital assets are being accepted worldwide. And in a way, and it's not something that we can avoid, digital asset has in a way transformed how financial transactions occur across markets, and enhancement and advancements in the technology with the blockchain and financial technology. All of this actually has enabled integration of digital asset into the financial system, and because of that, the behavior of the digital assets has caused some concerns to the regulator, because normally a regulator would like to see an orderly market where there's financial stability and protection of the investors. So governments and regulators are actively engaging to create a framework that ensures safe digital asset use by the public. So if we look at Malaysia itself, there is a lot of regulatory focus on digitalization as well as fintech. So we see that, for example, in the Bank Negara Financial Sector Blueprint 2022 to 2026, advanced digitalization is one of the 5 strategic trusts. And if you look at the Securities Commission Capital Market Plan for the past 5 years, 2021 to 2025, embracing the digital age is also one of the 3 regulatory trusts. So when we talk about the Islamic capital market, is part of the, in Malaysia, is part of the regulatory purview of the Securities Commission. And we have seen how Malaysia has been one of the first few countries in the region that had introduced a specific regulatory framework to facilitate the trading and offering of digital assets. For example, we had in 2019 introduced the Capital Market and Services Classification of Securities, Digital Currency and Digital Token Order, basically to prescribe what are digital assets that are considered as securities under the securities law in Malaysia, and what are the specific regulations that apply to these digital assets. From the Sharia perspective, an important milestone is that when the Sharia Advisory Council of the Securities Commission made their resolution or ruling with regards to the status of digital asset, and this was done back in 2020. And if you look at the basic definition of digital asset, generally we can see that it can be divided into two main categories: digital currency and digital tokens. I believe many in the room are familiar with that, what digital assets are and what digital currency is and what digital token is. But for the sake of simple explanation, a digital asset in very simple term means an asset that exists in a digital format and has identifiable value, whereas digital currency is a broad term that encompasses all forms of digital money, but in popular terminology, people would like to equalize digital currency with cryptocurrency. So cryptocurrency is a form of digital currency, but there are also other forms of digital currency like the e-money issued by banks. So the cryptocurrency is what we call the decentralized form of digital currency, whereas digital tokens are basically specific type of digital asset that are built on existing blockchain platform, and they normally represent various assets or utilities. Now, given the wide definition and coverage of digital assets, when the Securities Commission regulate and provide their regulation, they actually confine the digital asset in the capital market only for those digital assets that qualifies to be considered as securities. So for that purpose, the Securities Commission have given their own definition of digital asset and the components: digital currency and digital token. So for example, digital currency are just referring to the digital currency that represent value which is recorded on a distributed digital ledger, whether cryptographically secured, meaning the cryptocurrency, or otherwise, meaning the other types of digital currency. And these, the ones regulated by the Securities Commission, would only be the digital currency that are approved for trading on the digital asset exchange, which is licensed by the Securities Commission. And for digital token, it means a digital representation which is recorded in the distributed digital ledger, whether cryptographically secure or otherwise. So even for digital token, we recognize whether it is cryptographically secured or non-cryptographically secured. Now, those are the technical definition and categories. Now, I will zoom to the main highlight of my my presentation, that is on the key Sharia issues in the digital assets. Basically, the key Sharia issues here is based on the deliberation of the Sharia Advisory Council of the Securities Commission. So basically, in order to determine whether digital assets are Sharia compliant and therefore capable and permitted to be traded and invested in by Islamic investors, the Sharia Council look at three main issues. Firstly, whether digital asset can be recognized as mal or qualified assets from the Sharia perspective, where it has values attached to it. And secondly, whether digital asset can be classified as a currency or it is actually just goods or urud, we call it. And thirdly, how to classify digital token. So these are the three main key Sharia issues that has been considered by the SSC of Securities Commission. Maybe if you can go to the next slide on the one with the diagram, this highlights the SSC's resolution on digital asset. Next slide, yeah. So as you can see, there are two categories: digital currency and digital tokens. For digital currency, the SSC said, yeah, they can be recognized as mal or qualified assets, but you have to understand only the digital currency which have been approved for trading on digital asset exchange. So it's not just any digital currency in the market, because the ones which is approved on the DAX have been verified, scrutinized to see that they are genuine, has sufficient investor protection, there are safeguards to protect the investors. Okay, so this is the caution. So it's recognized as mal, but SAC also look at the underlying, because digital currency, as I said, can be cryptographically created. It can also be non-cryptographically created. So the digital currency which are purely based on algorithm or technology, whether this is currency, is named as cryptocurrency, is it really currency? So SAC seems to agree that it is not currency, because not all elements of currency has been met by cryptocurrency, and therefore it is only treated as urut, just normal assets. And if the digital currency is backed by asset, we have to see whether the asset is ribawi, like it's backed by gold or silver or money, or it is actually non-ribawi like the normal assets. So the rule on the trading of this digital currency backed by asset will be determined by the nature of the underlying. For digital token, again, the SAC come to the resolution that it's recognized as MAL under the urut category, but they have to fulfill three main conditions. Firstly, the proceeds from the issuance of that digital token must only be used for Sharia compliant purposes. And then the rights and benefits attached to the token must also be Sharia compliant, because tokens normally represent an asset or benefit or utility. So that asset or utility must be Sharia compliant. And if the digital token represents a ribawi item, it must follow the relevant requirements for the trading of ribawi items. Now let's go to the deeper Sharia insights. Basically what the SAC has done is just basic to look at the basic rules in terms of whether digital asset is acceptable or not from Sharia perspective. But when we look at the deeper Sharia insights, we have to really see how do digital assets create a genuine value from its issuance and its trading and investment. So that's the tricky part. Basically, if we are talking about the digital asset that is backed by the normal traditional assets or even the other financial assets, that would be easier to establish the actual value or the real value that it is creating. But if the digital asset is purely backed by mere algorithm and mathematical computation, that's where there are some issues in terms of identifying what's the real value in the investment and trading of these types of digital assets. So when we are evaluating this value created by digital assets, is it really aligned to the maqasid Sharia or other Islamic principles? Especially as I was talking about the digital currency, which is only based on technology. Whereas for the digital token, I think the digital token representing traditional assets like real estates, utility, we can clearly identify there is some value in the investment and trading of these assets. But as market develop, we have seen how even non-fungible tokens have been issued, as a token, and these NFTs, some people question whether it is really a genuine and real value aligned with the maqasid Sharia, or it's just something which is khayali or fictitious and based on imagination. So that's something which maybe requires further analysis. And another thing about digital assets is that, we have the common understanding that riba, gharar, and maisir are prohibited. But the complex way in which digital assets are being created, traded, and marketed, are there hidden behaviors that may create impressions of some elements of riba or gharar or other prohibited elements. So although cryptography was said to be, protected from hacking or tampering because of the blockchain technology, but we have seen a lot of cases of fraud, and that normally because of the hacking or of the exchange itself, the platform where digital currencies are being traded, or like the case of FTX. Basically, there's problem and abuse of the parties who are actually selling, the founder. I think we have read the news about Sam Bankman, right? So there can still be issues of elements that maybe create the impression of uncertainty, ambiguity, and potential of fraud. So in the long run, we have to see what is actually the real economic benefit of digital assets, what are the risk implications, and does it actually meet the Sharia compliance requirements, as well as the maqasid of preservation or protection of mal or hifzul mal, where it requires clarity, al-wuduh, it requires al-thabat, stability, it requires al-adlu, justice and fairness, and it also requires the elements of al-rawaj, or inclusion and accessibility. So that is a matter which is still under deep discussion among the scholars. Some scholars go to the extreme of saying that digital assets are haram. Some take the middle way of saying we recognize some digital asset, but not some, only the digital asset that can meet the elements of wudu, clarity, stability, and justice and fairness, then we consider it as permissible, but those that do not meet the criteria, we consider as not permissible. So those are some of the things. I believe my time, how many minutes do I have? Almost 2 minutes, okay? So maybe we can go to the next slide. Basically, if we go into more details on tokenization, a lot of people wrote about the benefit of tokenization. For example, it enhances liquidity, transparency, and accessibility for asset holders, because token will always represent assets, whether traditional or non-traditional. And the main benefit is, like I said, increased accessibility, enhanced liquidity, cost efficiency, and transparency and security. For example, real estate, digital securities like stocks and sukuk, arts and collectibles and whatnots. Some of the assets need to be scrutinized in terms of its Sharia compliance, but generally, token would have perhaps a better and easier recognizable real value and connection with the real economy. Now, another issue is with regards to hifzul mal, or protection of the asset. We need to really look at regulatory and risk management issues in terms of how we navigate regulatory variations, because different jurisdictions may have different treatments, regulatory treatment, and also Sharia views may differ from one jurisdiction and another. So regulation and governance of digital assets globally or cross-border would be a challenge. Risk assessment also is crucial to basically identify and mitigate potential threats in digital asset investments. There must be a lot of transparency, because transparency builds trust, and investor protection mechanism to protect them from fraud and market volatility. Sharia scholars play a huge role to provide guidance, ensuring compliance not only with the basic Sharia rules and principles, but also alignment with the maqasid consideration. Financial intermediaries and platform providers should play a pivotal role in ensuring soundness and integrity of the digital assets that they are offering, and whatever innovations should be done responsibly. Investors need to exercise caution, prudence, and sound judgment in evaluating complex financial products, and need to seek proper advice wherever appropriate. And regulatory bodies need to set standards and regulatory safeguards to ensure transparency, compliance, and investor protection in digital asset offerings and investment. As a conclusion, I would like to say that yes, digital asset has transformative potential. They can transform Islamic capital market by introducing innovative financial instruments which are efficient, cost-efficient, secure, and whatnots. In terms of Sharia compliance, aligning new technology with Sharia principles is essential to maintain credibility and integrity. But what is more important is actually genuine value creation that is aligned to real economic productivity and well-being will ensure stability, equitable growth, and alignment of digital Maqasid with Sharia, Maqasid Sharia itself, digital asset with Maqasid Sharia itself. So with that, with that I would like to thank the audience for your attentive listening. Assalamualaikum warahmatullahi wabarakatuh.
Wa alaikum assalam wa rahmatullahi ta'ala wa barakatuh. We now wish to invite representative of IBEAM, Madam Dafina Ahmad Hilmi, CEO Hong Leong Islamic Bank, to present the memento to our presenter. تفضلوا. Round of applause, ladies and gentlemen, for our presenter, Professor Dr. Unku Rabia Adawiyah. جزاكم الله خير الجزاء وبارك فيكم ونفع بكم.